morning's docket. That is case number 107571, State of Kansas v. Ronald or Ronell Burnett.
Michelle Davis on behalf of Mr. Burnett. May I please reserve 2 minutes for rebuttal?
2 minutes.
Thank you. Switching gears a little bit, the state convicted Mr. Burnett of first-degree murder. And we raised numerous issues in our brief. The state's first-degree murder conviction was based on discharge of a firearm at an occupied dwelling, and basically felony murder, that an occupant of the house was killed as a result. The thing that's interesting about this case is that apparently the house that was shot had tended to get shot. It had numerous other bullet holes in this house. Apparently there were 17, and the state moved pretrial to limit the defense from presenting evidence. The state was concerned that the implication would be that this was a drug house or that this was a house that involved criminal activity.
And you agreed that was you're trying to get that evidence in under a kind of a third-party theory. Is that right?
That's the state's argument. It was a state's motion, and the state argued to the judge that it shouldn't be admitted.
I thought both sides agreed that was the theory in which the evidence would come in.
Well, what the defense argued, 2 parts to the defense argument here. One was that the defense counsel wanted to be able to cross-examine the crime scene investigators regarding that they thought the theory here was that he was shooting out windows in retaliation because the windows in his ice cream truck had been shot out, Mr. Burnett. And so the defense counsel wanted to dispute that the expert saying that this shot came through the window that killed the victim in this case, because there were other bullet holes in the house. And that did the crime scene investigators investigate these other bullet holes, that the shots could have been fired in another way other than what the state claimed. So that was part of it. And, the prosecutor seemed to concede that a little bit, because the prosecutor said, well, she could instruct her witnesses just to say there was this other damage to the house, but then maybe not get into the events of the prior shootings. I think that was where the state brought this motion. They didn't want the details of the other shootings at this house, that this was a drug house, and this was a house that had been the site of criminal activity. But so there are 2 parts. The defense counsel, and there was a pretrial motion where defense counsel argued
counsel,
this.
I'm sorry, I just need to interrupt. I don't understand what the answer to the question was. Was the defendant wanted to get the evidence in to demonstrate that there could have been another source of bullets, basically? That was that it could have been somebody else who had another beef about this house who fired the shots, right?
And that was the second part. That was the second part where defense counsel said, our defense here is I didn't do it. There had to be some other explanation for this, because this was such a circumstantial case. The state was saying that Mr. Burnett was the likely shooter because this altercation.
He was mad, he had the beef, he had the argument, he was in the vicinity, blah, blah, blah.
Right.
It was a circumstantial case.
So defense counsel said, if I'm going to say we didn't do it, I've got to be able to say there could be some other explanation. Because otherwise, that's all you're left with.
Okay. So it wasn't, here's the other person, which is a typical third-party case. It was, there are a multitude of people who might have done this. That was the defense aim for putting in the evidence.
Yes, and Justice Rosen, to answer your question, the reason I was hesitant is because nobody really the defense didn't say third party here. I mean, neither did the court. The prosecutor mentioned it at the pretrial hearing, that there's some third party rule out there that this shouldn't come in. And so I analyzed this in my brief from a third party point of view, but the concern here is that you think of the third party rule as I'm pointing the finger at somebody else. I'm going to say Joe did it or Sue did it, and this is kind of a relevance inquiry, generally, the way the court conducted it, but you don't have that in this case.
Somebody else had a motive to do it is normally
Third
why
party.
it comes in.
Motive plus.
You don't really have that in this case. It's not like the defense was trying to point the finger at some other person.
Well, then what are you offering it for? What are the, I mean, You offered no suggestion these other bullet holes came on a specific occasion. They were just present. We don't know have any. They could have been there for 5 years. What
Well, none of this.
what
yeah.
are you suggesting that
None of this
their
evidence,
relevance?
none of this evidence ever really got developed because of the court's ruling. What defense counsel said is I should be able to get into the fact so I can cross-examine the crime scene investigators and so that we can counter the state's argument that this could be the only possible explanation, that there are other possibilities in the universe, that people, I guess, in Wyandotte County have a tendency to shoot this house. That was the defense argument, and it never got beyond that.
And the third-party rule, I should look at it, I guess, but doesn't it say that you can't use circumstantial evidence of someone else's motive if you've got direct evidence of the,
It used to say that.
yeah.
Now it's motive plus. You can put
Yeah,
in
motive
third-party
plus.
evidence if you've got motive
But,
plus.
but even the old rule relied upon the direct evidence tying the defendant. And here, what you're saying is, all the state had was motive and opportunity with regard to the defendant. Is that what you're arguing? That's all the evidence that the state had that Mr. Burnett did it.
Well, there was
And-
also.
and-
Go ahead. I'm sorry.
That's right. Yes, and then the only direct evidence would be the girlfriend who said that he had called her later, and her testimony. And in my brief, I'm arguing that I think what you're trying to say, the case law generally on this is where the direct evidence is so overwhelming and so strong that to allow the state to bring in some speculative or conjecture that somebody else isn't proper.
Well, what about that direct testimony from your client to Ms. Dixon?
Yeah,
That's more than circumstantial.
right. And I think that what I tried to argue in my brief is that the state isn't necessarily relying on that for the conviction. That's one piece of direct evidence, but their strongest evidence here was the circumstantial, the altercation, and this happened shortly thereafter, especially when Dixon, I think.
His presence, his admitted presence at the house or near
Right.
the scene, plus
Right.
coupled with a phone call.
Right, but and her testimony was difficult because, I mean, in terms of credibility, I think because the state, she claimed they had told her they would take her kids away and that the state had really leaned on her. And
The bottom line, though, is that it doesn't matter. It doesn't matter what kind of mountain the state had. What those third-party cases say is that the direct circumstantial distinction doesn't matter anymore. It should never have mattered, for that matter. It just doesn't matter. The state has its case, and the defense is entitled to put on its case, even if it's circumstantial. You can be convicted on circumstantial evidence, and you can be acquitted on circumstantial
right.
evidence.
That's
And that's really the bottom line of your argument.
Yeah, that's true. And I think what I was trying to get to is I think that the judge went too far in this case because right before trial, defense counsel said, can I at least bring this up to at least cross-examine the crime scene? And the judge says, no, it's not probative at all. At all.
And probative is the key word here. We call it the third-party rule, but it, bottom line, all has to do with relevance.
That's right.
If someone else has a motive, we're saying that's not relevant enough to come in if that's all you're using it for.
That's right. That's right.
And what you're arguing is that here defense identified relevance beyond just potential motive.
That's right. Yes. So it's our argument here that the judge's ruling just absolutely no evidence of this was too broad. And
How was this not harmless? Even if it was error, how was it not harmless,
of course I did cite
given the mountain?
I did cite the constitutional standard of no reasonable possibility that the error contributed to the verdict.
We've been saying we need to be firmly convinced that the result would have been different. That's what we've been saying for the last year and a half about the constitutional standard.
Firmly convinced that the error would have been different. I understood that to apply to instruction errors.
Only? Okay.
And since this was an evidentiary error that went to his right to present his defense and confront witnesses,
Okay.
that's why I was relying that the state has the burden of proof here to show that it's harmless because this was all objected to and preserved.
Even using that reasonable probability, there would have been a different outcome. How do you argue that?
Well, again, I'm going with possibility. I think that's what I argued in my brief. But you know, the probability, if you wanted to argue that standard, isn't more likely than not. It's more of that it casts enough uncertainty upon the conviction, that upon the result, that that there should be a new trial. Again, I argued that in my brief, is that this, as defense counsel said, that this was a very circumstantial case, and I think if the jury, the first trial ended in a mistrial, that if the jury had known, I just think this came down to, and the state argued this, one of their witnesses argued this in the closing, the prosecutor argued this, is that you got to convict Mr. Burnett because this is the only explanation for this. He's the likely guy. He's the only guy left standing in the room. And I think that if the defense had been able to get into this evidence about that there could have been some other explanation for this shooting, then I think there is a reasonable possibility of a different verdict. And I've only got a little bit of time left.
What's your justification for applying the constitutional standard?
That it violated his right to present his defense and his right to confront the witnesses against him. And I just quickly wanted to get into the denial of what happened here. This was a quick trial. This trial started on the 16th of February. On the next day, the 17th, the state's presenting their evidence. Then the 18th, the state rests. At the end of the state's case, they put on the detective, and the lawyer wants to bring in, he doesn't think that the detective's characterizing what Mr. Burnett had told him well. He wants to bring in this video and to show the interview with Mr. Burnett. And the judge just says, no, we don't have time for this.
Did he ever state where he believed that there was a mischaracterization or a contradiction or anything that was misleading by the detective? I mean,
He just didn't think that the detective was only giving the information favorable to the state and was not being complete. That's the only indication I got from the record. And again, the judge just sort of summarily denied this and says, you don't have time to do this.
Well, there wasn't summarily denied. He heard the argument and said, you know, this is the last witness. You've had an opportunity. You had the first trial. You had this trial to prepare a redacted video portion of the interview, and you haven't done it, and you haven't even suggested where it is that you're having a problem with his testimony.
Right,
So-
but the judge never made the inquiry as to how long would it take to do this. This was a third day of trial. It was a 4-day trial. And it was the end of the third, or in the middle of the third day, and the judge never said, how much time would it take you to do this? And just summarily said, no, I'm not going to allow it. And to us, that's arbitrary because the judge never made the inquiry of how long would it take. If they could have done it that night and presented it the next day, for example, but there's nothing in the record to support the judge's conclusion that you don't have time to do this. You're out of time. It's too late. The judge just said that, and so that's our argument. I'm out of time, so.
Do we have anything in the record that would establish that or corroborate the defendant's position that the officer was testifying differently at the second trial? I mean, that was the excuse for not having it redacted in advance, right? Is that the officer testified differently at the second trial?
You know, I'm not really sure on that. My understanding was they didn't present this testimony at the first trial.
That
Yeah,
the
so-
officer did not testify at the first trial?
That's what I thought, that
Okay.
they
The
claimed.
officer did not testify the officer testified at first trial, but did not testify regarding the interview with
Mr. Burnett.
with
and
Mr.
then-
Burnett.
And then that came in at the
Right,
second
at second
trial,
trial.
and then all of a sudden defense counsel
Strategy
like.
change is, I think, how the state put it.
Yeah. And then defense counsel said, okay.
Do we have any further questions? Thank you, counsel.
Before you get started, was there anything that should have clued defense counsel into the fact that the officer would be testifying about the interview at the second trial when he didn't at the first?
Not that I'm aware of.
And so what is there to support the district court's statement that you should have had an opportunity to redact this and had it ready for impeachment purposes when there was nothing to clue the defense into the fact that they would need it to impeach?
Well, I mean, the Detective Block was endorsed, and he testified more extensively at the second trial than he did the first. But defense had, the thing is, the defense had the transcript of the interview, of the video. There was a video and then there was a typed transcript. And everybody had that. The defense had it, the prosecutor had it. So defense counsel knew what Detective Block would testify to. Now, if Detective Block testified differently than what that transcript showed, he had the ability to cross-examine him. That's what, or to impeach him. And that's the purpose that was tendered for admitting the video, was to impeach Detective Block. Well, that still could have happened.
In theory, but apparently didn't bring it, right? Counsel didn't bring it. Wasn't that one of the other arguments later, that counsel didn't have the transcript available to do that?
Well, he had it available. Now, whether he brought it with him or
Yeah,
not,
I'm not
yeah.
faulting the state. I'm
Right.
saying one of the arguments is that defense counsel messed up by failing to bring it to court.
Right.
Okay.
And if that's the case, then it's, Judge, can we have a 10-minute recess so I can go to my office and get the transcript, which is a very different situation than however long it's going to take to redact a videotape. If it may please the court, I would, on behalf of the state, I would ask the court to affirm the decision of the district court. The bulk of the argument here this morning was on the exclusion of third-party evidence.
Let me ask you about that. It doesn't fit third party. The state's right about that. It doesn't fit the third party rule and its exceptions and whatever. It doesn't fit that because it's not about a person, another person committing the crime. So why wasn't it just relevant in the same way that much of the state's circumstantial evidence was relevant? Can you just talk to us about the relevance generally on that evidence?
Well, it's not relevant because there was nothing proffered, nothing or nothing either put into evidence or proffered.
Let me ask this way. Was the condition of the crime scene relevant to your case?
No,
It wasn't? You
not the
didn't have
condition
to.
as to before what happened on.
Was the state permitted to put in evidence about what the crime scene looked like? Was the state
Right,
permitted to do
yes.
that? And you would argue, of course, that that was relevant evidence for your case, wouldn't you?
Correct.
Okay, why is it not relevant for the defense as well?
Because what the state admitted was evidence that was relevant as to what happened on the evening of the crime, the evening.
It's the jury question on whether that actually happened at the time of the crime. I'm just talking about the condition of the scene. The state comes in all the time, don't they? And puts on multiple witnesses about this was here, this was there, body was here.
Correct.
I mean, the condition of the crime scene is relevant material in a murder case, isn't it?
It is.
So
But
why
the
is
state-
it only relevant for one side?
Well,
That's
because-
my question.
Well, it's relevant if there's some connection to the crime.
Well, there were bullet holes, multiple bullet holes in the side of the residence, correct? Some of which the state said were caused at this event.
Right. And the other ones, though, and I think if I recall the testimony correctly, had already been patched on the inside. So though there may have been some on the outside, they didn't go through to the inside. And I believe the record showed that was the case.
The record showed that the bullet holes that were there perhaps prior to this event had been patched.
Correct.
Was that was that a part of the discussion, part of the state's motion in limine that was the case? Or how do you know that?
I know because I read it in the record, or in the case. I don't know exactly at what point that, and how,
You don't.
where or when that
Okay,
was
but that,
argued. But I know that the record reflected it.
it was in the record, okay.
Was there evidence about the condition of the windows before the crimes? Wasn't the theory that there were at least some shots that went through a window?
Correct. Right. It was because I think as I understand it, was the shots that went through the window, was one of those that killed Rahi Larks.
And how did we know that? I mean, again, was there information about the condition of the window, and then was there forensic testimony about the path of the bullet so that they knew that bullet came through the window?
I don't recall specifically, but I believe from where the body was found in relation to the window, that was the conclusion.
Before you leave this area, would you touch on the issue of harmless or reversible error because of this particular issue?
Well, I think it's harmless because there's no evidence that anybody else was shooting that night at the house where the killing took place. There's no evidence that any other person, some nebulous, somebody might have had a reason to do this. Somebody else might have had a reason to fire shots, but there's no evidence that any other person did do that. It's all pure speculation. Secondly, the evidence, the defendant's admissions to Ms. Dixon and his subsequent letters, trying to get her to change her opinion, it shows that the result wouldn't have been different even if the court let all the evidence in about other damage to the house from prior shootings or any of that. It wouldn't have changed the outcome.
And is that our standard?
I believe so. I believe the standard is that we can be reasonably certain that the jury's verdict wouldn't have been changed.
Can you address the issues that were raised in Mr. Burnett's request for substitute counsel between the first and second trials? It seems to me that counsel for Mr. Burnett expressed concern about his client's confidence in his competency and ability to go forward with the second trial. And he stated, as it appears to be so shaken in my confidence to try this case a second time, I don't know whether I can rehabilitate that. I've tried during the first trial to do that, and evidently I've failed to do that. And the trial court seemed to hinge on his apparent success for having a hung jury in the first trial as evidence that he's competent, and that kind of overcomes any concern that Mr. Burnett has regarding his confidence. Just address that. Can you go forward with a trial with your own counsel saying it appears my client's confidence is shaken to the core, kind of thing?
Well, and obviously the defendant wanted new counsel, and I think, and a good defense attorney would say, "Hey, Judge, there's some problems here," and this is what Mr. Zimmerman did. He basically, I don't think he has confidence in me, and the judge then has to investigate, and he did. The record shows that.
I understand the other grounds, but
And not only did the court point out that that trial counsel wasn't unsuccessful in the first trial, the jury hung. He kept his client from being convicted. at the first trial. But then the court was asking questions, particularly of the defendant, and the defendant wasn't able to tell the court why his confidence was shaken in Mr. Zimmerman. He didn't have he couldn't give any example. He couldn't say what he couldn't actually say what Mr. Zimmerman did or did not do that caused him to lack confidence in him. The complaints that he did vocalize were all matters of trial strategy, which
I guess it's the distinction between the level of confidence and then the justifiable dissatisfaction. It seems to me that's the question here, in my mind. Is the shaken confidence so serious that it results in the justifiable dissatisfaction, or is it something else?
No, I think that's as in these situations, that's often the case, and that's the weighing that the trial court has to do, and I think that's what the judge here did, and I don't believe he abused his discretion in how in doing that weighing and making his decision.
In essence, you're saying that if there was dissatisfaction, the judge said it wasn't justifiable.
Correct.
But he was a little prescient about
I'm sorry, he was what?
ineffectiveness. He did foresee, because I don't think you can call it trial strategy to fail to have the transcript to cross-examine the officer, especially when at the hearing after the second conviction, Mr. Zimmerman admitted that he could have done a lot better job of cross-examining the officer if he had brought his transcript to court, and that it would have made a difference, and albeit he did equivocate on whether it would have changed the outcome, but there's no trial strategy contained within his explanation of why he didn't have what he needed to perform his cross-examination.
Well, and that's true, but it also doesn't indicate that it would have changed the outcome, because there was no indication, and neither Mr. Zimmerman nor the defendant was able to say what the Detective Block testified incorrectly or falsely or anything like that in his testimony. There was nothing in the record that shows that there was some reason to jump all over Detective Block based on his testimony.
Counsel, do you have any further presentation for us?
Unless the court has any other questions, I do not. I would merely ask the court to affirm the decision of the district court.
Any questions? I see none. Thank you, counsel. You have 2 minutes for rebuttal.
Excuse me, just in regard to the transcript issue, it's clear from the record that trial counsel did not have a transcript at the time, just didn't even have one at all at the time of the trial. And that came out in the motion on ineffective assistance of counsel and the motion for new trial, where a new attorney took over, and the trial counsel actually testified and said, I didn't have it.
Can you point to anywhere during Detective Block's testimony where there was testimony that was inconsistent or contrary to what was said during the interview that was in the transcript or that was in the video?
No, I can't, because trial counsel didn't make a record of it.
Well, you can look at the transcript and see. There's been no evidence offered anywhere that what Detective Block testified to was contrary to anything that was in the transcript or the video.
Right, all we have is what trial counsel said at the ineffective assistance of counsel hearing. He said, if I had had that, I would have been able to impeach, the benefit to it would have been, I could have impeached the detective, undermined his credibility. He doesn't tell us how he would have done that. And he said, if I had been able to undermine his credibility, then
Right, I
that would
understand
have
that,
supported our
but
claim.
no one's pointed to where he could
Right.
have done that, but maybe he could have. I understand.
Right,
Is the
and it's just not
transcript in the record?
No, it's not in the
Is
record.
the video in the record?
No. And the transcript that did get referred to at the post-trial hearings, the new attorney said, I went and got this transcript, it's a police transcript, it's not even in a form that could have been used at trial. So That's what we have. And going to the, I have 14 seconds left. All right, I'll just conclude on my comments then, unless there are questions.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.